Public International Law, Unit 2. So these are the important questions in Unit 2. We will see one by one. The first important question in this unit is different kinds of states and non-state entities. So what are the different kinds of states? The first is confederation. So confederation is an independent state. So it is an independent state and it is not an international person in international law. It is not recognized as international person in international law because it is a totally independent state. Then why to classify it as a state in confederation? It is to develop relation between states. Even though it is not an international person, it should still be enter into relation. So confederation state. The next is federal state. A federal state is formed by merging two or more sovereign states. So when two or more sovereign states merge together, it is called as federal state. It is an international person in international law. Exercises control over member states and citizens of state. So it can exercise its control over its member states. So it is formed by two or more states. So this federal state can exercise its control over its member states and the citizens residing in that state. Example is USA, Switzerland and India. The next is a condominium state. In condominium states, two or more states exercise control over a single territory. There is one weaker state and two or more powerful states take control over it, try to control it. It is condominium state. Example is England and France exercised control over New Hebrides between 1914 and 1980. The next is vassal state. Vassal state is a state which is under the suzerainty of another state. So it is under the dependency of another state. The example is during British rule, India was under the suzerainty of Britain. So it was a vassal state. This state is not recognized as an international person in the international law, a vassal state. The next state is a protectorate state. A protectorate state is an independent state within a state. So it is residing within a state but it is independent of it. A protectorate state has sufficient sovereignty to claim jurisdiction in another state's territory. So it is an international person. Example is Sikkim in India. Sikkim was a protectorate state before merging into India, but now it is a full functioning state of India. So the next concept is Calvo Doctrine. It has been asked first as a short note. So what is a Calvo Doctrine? This doctrine was proponented by Calvo of Argentina. So Calvo is a person who was residing in Argentina and he is the one who proposed this doctrine. So that is why it is called Calvo Doctrine. The doctrine states that state is not responsible for the losses suffered by alien persons during civil war. Say if a civil war breaks out in a country, then while controlling it or during the civil war, if the foreigner's property gets damaged or alien means foreigners property gets damaged or they take damage, then the state is not responsible for it. Why? The reason is if the foreigners are responsible, foreigners properties if the loss suffered by the foreigners, the state if takes responsibility during civil wars, then the big nations will try to interfere in weaker states' affairs. This doctrine began in Latin America. It has been asked as a short note. The next is a recognition of a state. So what is a recognition of a state? The definition is given by Oppenheim. Oppenheim says that it is to recognize new state as a member of international community and existing states declare it as a member of international community if it fulfills the conditions of international law. So if a new state it fulfills all the conditions of an international community or an international law, then the already existing states of the international community will recognize it as its new member. So what are the conditions to be fulfilled to be recognized as an international community member. According to Kelson, it should be politically well organized and it should have control over a definite territory. It should have a definite territory, it should be politically stable, and it should have permanent control over the territory. There should be a permanent government and it should be independent. It should have its own sovereignty. Theories of recognition. There are two theories, constitutive theory and declaratory theory. Constitutive theory. So, according to Oppenheim is the major exponent of this theory. He says that state becomes international persons through recognition only. So, according to this theory, if a state has to become an international member, he has to go through the process of recognition. Recognition gives rights and duties to states. Only after the state is recognized, it can be called as a state. It gets rights and duties as a state. So, the chief exponents of this theory are Hegel, Ancelotti, and Oppenheim. The Judge Lauter Pact states that it is the legal duty on states to recognize new state. So the judge states that if a new state is formed, then it is the legal duty of the other states to recognize it as a new state, as a state. Criticism to this theory. Judge Lauterbach's statement is wrong. So it is not the legal duty of states to recognize any state as a new state. And rights and duties only through recognition is wrong. Sometimes some states accept. So what happens is sometimes some only few states accept it as a new state, even though some states do not accept it, do not recognize it. The example is China. China was before not recognized in West, but later on it was recognized by a few states, and it was a well functioning state, China, at that time. Now it is recognized by all of the states. The next is declaratory theory. The declaratory theory states that statehood exists without recognition. So what this says that recognition is not necessary. Statehood exists even without recognition. Recognition is just a formality they have to do. If a state forms, then it is a state, well-functioning state. It has to not go through recognition procedure. The recognition is just for formality. The chief exponents of this declaratory theory are Hall, Wagner, Bradley, etc. Criticism. So when recognized, it acquires certain legal effects. So the statement that recognition is just a formality is wrong, because after getting recognized, it acquires certain legal effects. The state acquires certain legal effects. So these are the two theories. The next is modes of recognition. There are two modes of recognition a state has to go through. It has a de facto recognition and the next is de jure recognition. A state can get two types of recognition, a de facto recognition or a de jure recognition. The first, de facto recognition. De facto recognition is a lower type of recognition. It is the first type of recognition. If the existing states, if they think that the new state is not stable, it does not have any stable government, then they give this de facto recognition to it. So according to Oppenheim view, new state, if it is not stable or does not fulfill all recognition requirements of the international law, then de facto recognition is given to them, those state. And Judge Lauterbach says that to establish a relation with a diplomatic relation, de facto recognition is given to establish relation with the state without having any diplomatic relation with that state. The next is the de jure recognition. De jure is the second step, it is the final step and it is a major recognition. It is granted when state is stable and fulfills all the recognition requirements. Professor H. A. Smith gave three conditions to get this de jure condition. There should be a reasonable assurance of stability and performance in that state. The government commands general support of a population. Government should command the general support of population. And the next is the state should be able and should be willing to fulfill international obligations. Then this de jure recognition is given. What are the legal effects of acquiring de facto and de jure recognition? The state will be now entitled to sue in courts of recognized states. It will acquire sovereign immunity to itself and property in courts of recognized states. It will acquire sovereignty of property. It can sell property to other states. It can sue in other states. Then succession and possession of property in recognizing state territory. It can enter into diplomatic and treaty relations with other states. And The effect to pass legislative and executive acts of recognized state. Before recognition, whatever executive acts the state has taken out, after recognition, it will be recognized. Those executive acts will be recognized. Even past executive acts will be recognized. Case laws. Luther versus Sagar. So this is a Russian case. Russia had the de facto recognition at that time, not de jure. It has the lowest de facto recognition. Even though it had de facto recognition, the case went in favor of Russia, and it was held that there is no difference in de jure and de facto recognition. The next case is Bank of Ethiopia versus National Bank of Egypt and Liquori. It is Italy's case. Italy had de facto recognition at that time, and the case was held in favor of Italy at that time. The next major case is Aranzazu Mendi case. It is in this case there was a dispute regarding ownership of ship between a de facto country and a de jure country. The de facto country was General Franco and the de jure country was Spain. They had dispute regarding the ownership of ship. The judgment was in the favor of de facto country and not de jure country. So these are the modes of recognition and their legal effects. The next is retroactive or retrospective effect of recognition. So what is a retroactive or a retrospective effect of recognition? Meaning, when state is recognized, its prior acts are also recognized. So when a new state acquires recognition, whatever the prior acts it has done, whatever the prior legislative acts, executive acts it has done, they will also be get recognized. De jure recognition has a retroactive effect. So the only de jure recognition has retroactive effect. Object is to establish a friendly relation with other state. So why they validate their previous acts? It is to establish a friendly relation with that newly recognized states. The case is Civil Air Transport Incorporated Co. versus Central Air Transportation Corporation. So this case is of China. So in China, there was Chinese Revolution, and it has the de jure recognition at that time. It went through Chinese Revolution. So the ruler of China, Chiang Kai-shek, he develops his headquarters in Formosa. So the appellant is an American company. The appellant of this case is an American company, and the respondent he was Chinese. But after revolution, he flees to Peking and takes loyalty of Peking. So Peking give him citizenship and declares that all his property in China is for Peking now. But this Chinese ruler Chiang Kai-shek, what he does is whatever the respondent's property is there in China, he sells it to American company. So it was held that this selling of property was valid because it had a de jure recognition. The next concept I will cover in next video.